let's get started here. Hal, thanks for jumping in, and thank you everybody for being here. My name is Paul Hitchcock. I'm with the firm Barth Calderon, asset protection, estate planning, business planning firm located in Orange County. You can see our headquarter office there, and we have the founder and senior managing partner of Barth Calderon talking about this new Corporate Transparency Act today, Harry Barth, who is in high demand for his talks across the country. We put in about 40 workshops a year everywhere, and this is a big topic. Hal Brody is an incredible Vistage Chair in Northern California. Hal, I hope it's okay if I say put you up there, pump you up a little bit.
It feels a little weird, but yeah, sure, why not? Can't hurt.
No. Yeah, Hal's been a Vistage Chair for quite a while, and so Hal aligned with Harry on this to get this information out. So as we get into this, a couple things. One is please put any questions you have in the chat. You can do that as we start going along here. Harry's got some important material to get out. We'll get to the questions. Any and all questions, we want them. We'll answer them live here on this webinar. And then also, as I said, I'm going to record it. So we'll send that in a follow-up email few days afterwards. Hal, I want to start with you and tell us a bit about what you're doing with Vistage as we go over to Harry after that.
Thanks, Paul, and thanks for those very, very kind words. I don't know if they're deserved or not, but I'll take them. These days, I've been with Vistage around 11 years now. Been a great fit for me. I got recruited for it back in 2012, I guess, 2011. And over the years, I've had several different groups. I started with a small business group, which is kind of my bailiwick, I guess. I owned lots of small businesses over the years. At some point, I opened up a CEO group with some bigger businesses, and then eventually I had a key executive group and then a trusted advisor group. So I had 4 groups going for a while. These days, I've decided to cut back to just do CEOs. That's for me the most fun. We think alike, I think. We connect on a different level. So I've got one very, very active and fun CEO group with probably the 14 kindest people I've ever met in my life. Yeah. I'm in the process of starting a second one. This one's going to be a little different, mostly to stretch myself, if anything. I'm going after folks that are more PC or VC funded, PE or VC funded. As opposed to my history has mostly been bootstrap, and most of the folks in my group have been that. I've had a few come through that are more investment oriented, but I keep running into people, especially out here in the Bay Area, that use outside investors, and I want to learn about it. So I figure one of the best ways to learn is to admit you don't know much, and my questions may be dumb, but they will hopefully bring out some good conversations.
Love it. No, thanks, Hal. Fantastic. I'll tell everybody as we get into Harry here that contact information for Hal and Harry will be up in chat. Harry, what do we need to know about this new law?
Okay. Well, good morning, Hal. Good morning, Paul. And Hal, good to see you again. I've seen you before. So, so Corporate Transparency Act. Oh my God. It seems to be just such a critically important act that nobody knows very much about, and how it applies and how it doesn't apply. And hopefully we'll pull back the covers today and pull back the veil, and everybody will learn what the government is up to significantly. So just from a definitional point of view, one of the definitions you'll hear me use throughout the course of our morning together is the term FinCEN. FinCEN is the Financial Crimes Enforcement Network, and it is a subdivision of the United States Department of Treasury, and they are the group that is responsible for enabling and implementing the Corporate Transparency Act. Corporate Transparency Act was passed in bipartisan legislation in 2021. It was delayed in its implementation to 2022 and then delayed in 23, and it launched January 1st, 2024. So it's just about 100 days old as far as it's concerned. And what is it? It's the compilation of, and it's very important to understand what it is, because we have to understand what it is to understand how it gets implemented. What it is a compilation or registry of pretty much every small business in America. It's just it's this compilation is not a public compilation, Hal. It's a private compilation for the use of law enforcement domestically, even internationally. And the goal of it is to determine who are the human beings behind the shelf and store company, the empty shelf companies. It came as a result of 9/11, came as a result of the Patriot Act, came as a result of the Panama Papers, the Pandora Papers, where terrorist financing, money laundering, tax evasion happens behind these small businesses, and the government doesn't know who is behind them, and it has a difficult time enforcing. So they passed the Corporate Transparency Act to build this database. It applies, Hal, to every single LLC, every single limited partnership, every single limited liability partnership, and every single corporation in America that's not exempt. And we're going to learn about that today and what the exemptions are. Is the government serious about it? Well, we will learn that every day that an entity is not in compliance, it's a $591 a day fine with no maximum for each violation. If it's a willful violation, Hal, it's a $10,000 criminal fine and up to 2 years in jail. It's a felony. So, are they serious? Yes, they are. There have been a couple of challenges to the act. There was a National Small Business Association versus Yellen, and another one, Brody versus Yellen, attacking the constitutionality of the Corporate Transparency Act. The Yellen case, which was in the Northern District of Alabama, the judge in a summary judgment said, yeah, this is unconstitutional. Federal government can't do this. Congress does not have the power. But what people need to understand, that ruling, Hal, only applies to the members of the National Small Business Association and not the rest of the country. And you also need to know that it's already been appealed by the United States Department of Treasury. And, I've been doing this for 50 years, and my best intelligence, whatever that's worth, is that more likely than not, the Corporate Transparency Act will stick for the vast majority of it. There may be some parts of it that are questionable, which are easily fixed by Congress. The other case, which just was filed, basically challenges Congress's right to do this because the formation and control of businesses and entities should be in the domain of the state and not in the domain of the federal government. We'll see where that goes. But as far as the world is concerned right now, this is in full effect. So again, like I said, notably, you'll notice I said that trusts themselves were not, because they don't register trusts with the Secretary of State's office, are not part of the Corporate Transparency Act. But if a trust owns a business that is registered, then the trust becomes an entity. And I'll explain that to you in a minute. So I think what's important to understand, so we got it. So we have all the businesses, Hal, that were formed prior to January 1st, 2024 that are not exempt. The estimate is there are 33 million businesses that have to be registered under that component. And every new business after January 1st, 2024 has to be registered. Let me give you some time frames so we understand. For new businesses, new LLCs, new corporations, new limited partnerships that are formed after January 1st, 2024, from the date that they're born at the Secretary of State's office. And Secretary of State says, okay, Hal, your LLC is good to go. We have 90 days to bring it into compliance. If it's not in compliance by the end of the 90th day, $591 a day fine. For all of the entities that are pre-existing to before January 1st, 2024, and this go back 20 years, 30 years, 40 years, doesn't matter if they're not exempt, they need to be brought into compliance by December 31st, 2024, effective January 1st, 2025. They've been to compile $591 a day fine for a violation. All right, with no cap, there's no maximum on that. It's probably one of the questions of constitutionality. So let's talk about who's exempt from this. I think that's critically important. And the main exemptions that impact Vistage members. I'm a Vistage member and I've Vistage speaker, as you know, for, oh my God, 15 years, longer than you've been a chair. And so let's talk about who's exempt. Large public companies are exempt from complying with the Corporate Transparency Act. So public companies, New York Stock Exchange, American Stock Exchange, NASDAQ, they don't need to comply. Why? Because everybody knows who the CEOs are. It's all public. The SEC regulates it. We know the human beings behind the veil, so it's not. So they're not, and this is targeted, Hal, to the two gals that own the hair salon, that are a small S corporation in California, because it's in their back office where cartel activities and terrorist financing happen. It doesn't happen in big public companies. It happens in small businesses behind the veil. So big public companies are exempt. Registered investment advisors, and for you, venture capital fund advisors, who are also registered with the SEC, and or state regulated and or FINRA regulated. We know who they are. They're fingerprinted. We know their backgrounds. They're exempt. Insurance companies and insurance producers are exempt from filing for the same reasons. They're highly regulated by the states. They're licensed. We know who they are. Highly regulated financial companies, banks, credit unions, registered securities brokers and dealers, for all the same reasons. Trust companies, highly regulated. We know who they are. They don't have to file. Tax exempt organizations, nonprofits. The small nonprofit that's saving the cats, saving the dogs, saving the whales. If they're nonprofits, they don't have to file. And also political organizations don't need to file. And governmental authorities don't need to file. And subsidiaries of exempt entities. This is important. Subsidiaries, not brothers and sisters, not sibling entities that we'll talk about in a moment, do not need to file. So if the main entity is exempt, they don't need to file. And the exemption that's most likely will impact yourself and all of your members is what they call the large company exemption. And this is an and, not a or. So if we have, the company, Hal, has 20 or more full-time employees, not contract employees, not part-time employees, full-time employees is defined by state law, and they have their office in the United States of America, and they have over $5 million of gross sales, they're exempt from filing under the Corporate Transparency Act. So let's just turn around and put that into proper perspective. So let's take my law firm, Barth Calderon. We're a pretty good-sized law firm that I own. So do I have over 20 full-time employees, Hal? Yeah, I do. Is my office in the United States? Yes, it is. And do I have over $5 million gross sales? Yes, I do. So my company, Barth Calderon, LLP, is exempt from filing under the Corporate Transparency Act. But as a result of being an estate planning attorney, as a protection attorney, corporate attorney, and the work that we do, I have 12 other entities that I own, that own my real estate, that own my investments, that own my intellectual property, all of the other businesses that I own that do not fall within that exemption amount. So I have 12 entities myself that need to be brought into compliance under the Corporate Transparency Act. Since, most of you members, if they may manufacture widgets, and which we'll talk about in a second, they'll have their business, but then they'll have an LLC that leases the land, that owns the building that they work in. So the business might be exempt, might fall under that category, but the real estate component does not. So that's important. And so we get to understand those are the exemptions to the Corporate Transparency Act. So what we're going to do today, Hal, you and I, we're going to form a company in California. We're going to call it H&H LLC. And of course, what are we going to manufacture? We're going to manufacture widgets, and we're going to have a couple of DBAs. Widgets are us and widgets are them. So we're going to talk about the formation of a new entity and how we bring it into effect and how the Corporate Transparency Act affects us. And then we'll go back and look at all the older ones, the 33 million of them. But when you understand what we got to do to put one together, this will start to come into focus. So you and I on April 1st, on April Fool's Day, the Secretary of State in Sacramento blesses us with H&H Co. LLC. So we now know we have 90 days from the time that the Secretary of State said go to bring it and file it under the Corporate Transparency Act with FinCEN. So what's important, critically important for you and all the members to understand is that our company that now is required to file is the responsible party for reporting all the components of the CTA. So what do we and how do we report our company? Everything must be reported electronically to the www.fincen.gov website. And so what do we got to tell them? So for our company, we've got to tell them the name of the company. Okay, H&H Co. LLC. All right, done. Then we must give them all of our DBAs, doing business as widgets are us and widgets are them. Then we must give them the actual physical address of our company, not a UPS suite, not the attorney's office, not the accountant's office, not a post office box, where the company is. If it's at home, it's a home address that must be given to FinCEN. In addition, we must file a unique identifying number, which normally in our case, Hal, was we got an EIN number from the IRS. You know, we started a company, and so we give them that EIN number. And now we have given out, if it's a single member, tax disregarded LLC, which is used quite a bit, then it's our social security number that must be given to FinCEN. So now we have the reporting company. So we have H&H Co. LLC is the reporting company. So now once we have reporting company, the next thing we must report to them is, so you'll see the term BOI, beneficial owners of interest. Who owns it? All right. So in our particular case, we have two owners, Harry and Hal. And so if we own more than 25% of that LLC, that corporation, or that limited partnership, we have to report, the company reports us as its beneficial owners. So what do we have to provide them? So we have to file with FinCEN, Hal Brody, your name. We need to file your home address, same thing. No attorney's office, no accountant's office, no UPS suites. And we must send to them a color PDF copy of your California driver's license and or your passport unexpired. That must go to FinCEN for every beneficial owner of interest that owns more than 25%. If they're a minor, they're exempted from that, but their parents have to file. When the minor has reached the age of majority, they need to file. So everybody who's an owner, now a tip for everybody listening in today is that most of the time law firms are the ones that are doing this on behalf of clients for a multitude of reasons. One, you get attorney-client privilege, and two, it's a felony not to do it right. So it's kind of weird. But anyway, strong suggestion, Hal, you're involved with companies, lots of companies, small companies, this is your breadbasket. If you go, we can't do this for you. If you go to FinCEN's website and open up an account, which I think is a smart thing to do, and, we can't do it. Why? Because they want to know where you go to, high school, where do you go to elementary school, what's the color of your first dog, and two-factor authentication. And you give them that information. Hal Brody, such address. Here's an uploaded copy of my unexpired passport. They will grant you a FinCEN number, a unique identifying number that you'll have. Took me about 30 minutes to get mine. And what that does, so now on every time you're required to report, you just give him Hal Brody, number so-and-so, so-and-so, and so-and-so. We don't have to give your residence address and upload that information every single time. It's a smart move to make. It's optional, but it really makes no sense not to do that. So all the beneficial owners need to report. There are no exceptions. Okay. When someone says they're not going to do it, then they really can't be part of Hal and Harry H&H Co. They just can't. Because that'll put our company not in compliance. They'll be subject to fines and criminal penalties, and so will we. There's just no exceptions in this. But it goes further. It goes further because it's not just beneficial owners of interest. I wish it was. It's also anyone that has substantial control. And so we could have had Hal, we could have said, hey, look, for our LLC, we're going to have Paulco, it's a California corporation, be the manager of our LLC. We're basically going to be a couple of passive investors, and they're going to manage the company. So since Paulco is now the manager of our LLC and has control, and now what does Paulco need to report? Every C-suite executive, the president, the CEO, the COO, the CFO, if they have any substantial decision-making authority over our reporting company, every one of them needs to report that information. If they have a board of directors, Hal, that can remove and replace the C-suite members, this could knock off the CEO and put in, a new CEO, then every member of the board needs to report as well. Oh my God. So you could see from a simple Hal and Harry Co., H&H Co., we're now up to about potentially 15 to 20 reports for our reporting company. No exceptions. Now it gets better. So now, how we've been doing good estate planning for over the years. We've been doing asset protection. And I tell you, hey, Hal, I want to make sure that your ownership interest in H&H doesn't go to probate in California if you die. So we put it into your living revocable trust, which is smart, or your asset protection trust, or your dynastic trust for your children, or, a generation skipping trust, or one of a multitude of trusts, both simple and advanced. So now, although our trust is not a reporting entity, it owns 50% of H&H because you put your 50% interest in the trust. So now the trust becomes a reporting entity, and here's what has to be reported there. Who created the trust? Maybe Hal and spouse, because the creators can move assets in and out. Ugh. Who are the trustees of the trust that control the trust? They have to report. Who are the trust protectors? In more advanced trusts, we have trust protectors who can remove and replace trustees. Who are the beneficiaries? And in some cases, in many cases, in trust, there are little things called like powers of appointment that allow certain things to be directed in different directions in the trust. Whoever holds a power to change the direction of an asset also must report. So we have the reporting company, we have the beneficial owners, we have all of those in control and how everything is held. I was working with a Vistage Chair recently in Texas, and everyone there's an oil and gas business. In your area, venture capital, private equity, high tech. There, everyone's drilling oil and gas. So he says to me, he says, every single time one of my members drills a well, we form an LLC. Why? There's a lot of liabilities. Things blow out, they catch on fire, people get hurt, there's environmental issues, pollution issues, problems. It's an LLC, which it should be for asset protection purposes. So that LLC now doesn't have 20 employees, hasn't done $5 million gross sales yet, and it's in Texas. It's a reporting entity. Now, he says, when people invest in those, or entities invest in the drilling of that well, usually they're LLC. So you might have 4 LLCs, LLC 1, 2, 3, and 4, who are the investors in that one. So each one of those LLC owners and all of their controllers now need to register to the Corporate Transparency Act. And the vast majority of those LLC investors, Hal, are held by holding companies, larger holding companies. So they need to report, and then it goes into trust, and they need to report. I think we counted that it was close to 50 or 60, in some cases, reporting that have to take place to make that happen. Wow. And so this and this all has to happen for our new entity, Hal, within 90 days of the time that it was given birth. In addition, for new entities formed after January 1st, there's something else. It's called the company applicant. So let's say, Hal, you came to my law firm and said, hey, Harry, why didn't your firm, file this thing for us here in Sacramento? I say, sure, fine, we take care of it for you. So my paralegal, Cheyenne, one of my paralegals, files the paperwork with the Secretary of State in Sacramento. So she is the filer. The filer needs to report. She needs to give her information that she did it. Now, if I am the supervising attorney that told her to form that LLC and the structure of that LLC, I need to report. So Harry reports as the company applicant. Cheyenne reports, as a company applicant. So that gets added to the mess. That, Hal, doesn't apply to any of the older entities. The company applicant of who created the limited partnership 25 years ago doesn't matter. So what a conundrum we face in looking at this. And the fines and penalties are egregious, and we don't have any exceptions that are involved. And then we have changes. So Hal, if you decide you've had enough with California and you're going to move to Nevada, wherever it may be, and you have your FinCEN number, you have 30 days to report your new address and your new driver's license. All right. If we don't, we're out of compliance. And it's our company, H&H, that has the responsibility to make sure that all of its owners keep their information up to date with FinCEN. If they don't, we become liable. So what does that tell us? And this becomes an opportunity for all of our members as well. And in when we form this new entity, Harry and Hal, H&H, one of the things that we did is in our new operating agreement, in our new shareholders agreement, or in our new limited partnership agreement, we have a new subsection called Corporate Transparency Act, which describes the act and then says, if you want to be a member of our company, you must comply with this act. If you don't, you're thrown out and you'll be bought out at 50% of book value, some penalty associated with it. You need to comply. So every single new operational agreement should have CTA language in it, but it also tells us, looking backwards at every existing shareholders agreement, operating agreement, limited partnership agreement, which usually, Hal, is woefully out of date. They may have formed that corporation 12 years ago, 15 years ago, 25 years ago. It's intergenerational even. And you look at the cap table, and some of the people owning this, they're dead. They've moved on to beneficiaries. They've sold out to others, and the cap table hasn't even changed in the shareholders agreement. We have to now, for all the older entities, we need to track down everyone who has control and every owner of greater than 25%. There could be spouses that are divorced, not even talking to each other. They don't even know where the hell they live. And now we have to get that information, hopefully a FinCEN number. And since there are no exceptions, the FinCEN, the Financial Crimes Enforcement Network, cannot accept a filing unless it's complete. So if we had 59 reporting interests and we reported 57 of them and 2 of them are holdouts, FinCEN has been instructed not to accept our filing until it's complete. And therefore, we come out of compliance at $591 a day. I think a little bit of that is going to be found to be not quite constitutional, in the enforcement of this, but it is what it is at this moment. That is what it is. And now that opens up another issue for all of us, and that is the AICPA, for example, has said to all the CPAs, do not touch this with a 25-foot pole. This is the unauthorized practice of law, because you have a couple of determinations that have to be made. For our newer entity, Hal, we know where we're going. We know who the owners are. We know how the structure is. We know what the agreements look like. For all the older ones that we have to report by December 31st, 24, it's a deep dive. We got to discover everybody. And then you have 2 legal things that have to happen. One legal thing that has to happen is control. What is control? For example, we can have one person in our company. We could have a company that's Hal, Harry, and Paul, 33 and 33, and then we have one person at 1%. They're not at 25, but they have voting, the voting control, the 1% voting control that we have, non-voting control, they need to report. So we need to determine control. Who has control? And that's a legal opinion. And then when you look up to the people have done appropriate and proper asset protection planning and estate planning, so more likely than not, the ownership interests are going to be in some form of a trust. Then that whole estate plan needs to be analyzed to who are the controlling factors in a trust, and that's not so easy because they got investment trustees and directed trustees and administrative trustees and distribution trustees and protectors and committees of protectors and power holders and creators and settlers and it goes on, beneficiaries, goes on and on and on. So you have this burden that's being placed directly on small business in America. 33 million of them, that have until the end of the year to figure all this out and get it reported properly to the government. And not very well liked. And then the other issue that we face is all this information. So we have all of this, we'll call it sensitive information. Hal, I have your address, I have your driver's license, all that stuff. It's being transmitted to the law firm. Law firm is transmitting it to FinCEN if we're filing it for you. We have to protect that information. All needs to be encrypted up and down. There need to be secure portals to hold everything, because even on FinCEN's website now, they're telling you, watch out. There's scammers that are coming out all over the place. There are people trying to intercept that information to use it for nefarious activities. So we have to, all of a sudden, the cyber consequences of this are also quite traumatic. So some people who, having heard that small case in Alabama, are saying, well, it's unconstitutional, I don't need to comply. It's very important that all of our members understand only applies if you're a member of the plaintiff group. For everybody else, it applies, and it's being appealed. And like I said, best intelligence is that the 11th Circuit Court of Appeals more likely than not will overturn the Alabama court judge's decision, and we don't expect other district courts, circuit courts, or the Supreme Court to overturn the act. There may be some components of it that are not kosher, not right. And those components can be easily fixed by Congress. And one of the reasons for that, not only is it bipartisan and has a noble purpose, most of the modern Western economies in Europe already have something similar to this, and the modern Eastern economies as well. And just, hey, a simple thing. You can't buy a piece of real estate. You can't do any transactions unless you sit there and get it notarized, right? You got to give your address. You got to give your driver's license. If you could do it there, why can't you do it? He said, I don't see this being overturned. The judge.
Harry, that FinCEN site is up there in the chat.
Great, thank you. So we have that availability. And then, the judge in the Alabama case says, he said, he starts by saying, there's a lot of legislation that's passed, which is stupid and ridiculous, but it's constitutional. He says, and then we have an act like this, in his mind anyway, that has a noble purpose, keeping us safer, all right? Helping, knock out rotten activities, which affects so many of us, even doing venture financing, private capital. You know your client. Who are you dealing with here? Is this, you may be making an investment in a company, but who's really the one making that investment? Are they laundering money? Is it laundering money for a cartel or a terrorist organization? We don't know, because there's all this layers of LLC. So that's why this is in place. He says, as noble as it may be unconstitutional as to whether Congress had the power to do this. So you got a little bit of tug of war that's going on. My suggestion to our demographic is that they file. No harm foul. And the other thing too is not an annual filing now. It's one and done. Once we have our organization, absent changes, it's one and done. We're filed, we're done, we have all the people in place. Of course, I don't know how you and I in our company are going to, as our company grows and expands, are going to be able to enforce that all of its owners and the trusts, that we don't have everything to do with every single day, is in compliance, because it's the company responsibility as a reporting company to make sure all of its components are filed. So hence, this is an awful lot of what a lot of people don't realize the depth and structure of the Corporate Transparency Act. Now, there is another piece of legislation moving through Congress that I want to share with everybody. And in that piece of legislation, which is passed by the House, not yet passed by the Senate, and not signed by the president, don't know if they ever will be. And it's mostly around extending some of the time limits. When this act first went into effect on January 1, we only had 30 days from the time that it was born at the Secretary of State to do all this. Ugh, or $591 a day fine. They expanded it to 90. So changes, changes can happen. Somebody dies, their shares or ownership interest in a company goes into probate or goes into trust administration. When it comes out of probate or trust administration, very important, it comes out and it's given to the beneficiary, they only have 30 days to bring it into speed. So the new legislation for changes ups that to 90 days, more reasonable. And the new legislation also changes the due date for the 33 million pre-existing companies from December 31st, 24 to December 31st, 25. It's not yet law, but since it's mostly around extensions of time, more likely than not, it may pass. But it also emphasizes in there in some really weird language, grammatic, you're reading language that you don't quite even understand, basically is an instruction to the Department of Treasury saying, hey, look, if we grant this extra time, there is zero exceptions. None. You cannot accept anything that's not complete. Okay, so if we have a rogue person, well, that basically means that you and I, Hal, we have to turn them in. Because if we don't turn them in, we could potentially get fined and see willful non-compliance. And if they don't comply, causing our company to not be in compliance, they could be fined and they could be jailed. Ugh, ugh, ugh. So even though this is not an advertisement for lawyers, I have a big law firm. We've been working with Vistage guys for, my God, 30 years, and guys and gals. But here's what we've done, so people can have some semblance of an idea. It costs nothing to go on the FinCEN website and file your stuff. But whether you should do it or not on your own is a decision you make. So, for example, on all of new entities that Barth Calderon has done from January 1st on, we've increased our cost of an entity by about $400, and we just do it. We will put down the map of who the owners, the controllers are, the trusts and everything. And for that $400 and $250 to file, we will then take that new entity after it's born. We will give it to a filing service that we've created, and they will sit on the FinCEN website, spend the 3 hours necessary to get all that stuff uploaded. I think it's money well spent. And then for existing, the 33 million, a little different. There's a little more challenging. So there we said, you know what? Some of them are simple, some of them are extremely complex. And we're not going to sit there and say, well, how many owners and how many this and how many trusts. So we just said, hey, look, we'll analyze any of them for $595, and then we will turn around and file them for $250. They could use it, not use it. That's up to them. But that also gives them at least attorney-client privilege at what they do. And it's not easy to make these determinations, because if you don't have a good working interest in estate planning, it's a problem. Now, opportunity is for every member and every member of our constituency to relook at their corporate and LLC governing documents, get them up to speed, get rid of people that don't belong there, throw off. I have like 3 LLCs that have just been sitting on a shelf. I did them and I never used them. I get rid of them. I don't need them. Those are exactly the things that they're after. I think that that is an opportunity to bring all our documents up to speed, and I think that is very, very important. My concern is that as you know, Hal, we've been well known for asset protection, estate planning, and all the things that we do, and I'm concerned about the chilling effect on people doing the right thing. People saying, well, I got to form 2 or 3 LLCs, but I don't want to register them with FinCEN, so I'm not going to do it. So now they have unlimited liability where they should have had limited liability. And and or things wind up in probate that should never wind up in probate because they were fearful of registering something with the government. I don't blame them. We all are. We've all seen how the government works, but we don't want to let the tail wag the dog. It is what it is. And so that needs to be done. And, pretty much I think that is everything everybody needs to know about the Corporate Transparency Act. We'll get a question every once in a while from a Vistage member who has an ESOP, for example, and or has a virtual business. So on ESOP, they said they have to file. Well, usually there are not too many ESOPs that are below 20 employees and less than 5 million sales. It's just not applicable. It's a lot of money to do an ESOP. But should it be, then the trustee of the ESOP trust and whoever controls the ESOP will be a reporting person under the Corporate Transparency Act. And then people say, well, what if it's an old virtual business, doesn't have an office? Well, it does. It's wherever that computer is that they're working on. If it's at your house, it's at your house. It needs to be reported. So, but people do need to understand this is not, repeat, not a public registry. So when we put a client in Wyoming, for example, and form a Wyoming LLC and authorize it in California, we do that because Wyoming doesn't publish who the members are and who the managers are to get privacy. I think it's really important. But even though we have to report that under the Corporate Transparency Act, the Corporate Transparency Act still does not make that public. Even in a lawsuit, it does not make it public, allegedly. So we'll see what the government does with that. It's a little too soon to tell. And so with that, Hal and Paul, questions that we may have?
Well, I have one, and Hal and Harry, this is applies to both, and Hal in particular, because you said you're building out the group with VC backers and so forth. We got a call here, you may remember this, a couple of weeks ago from an advisor dealing with VC-backed companies, and the company didn't do well, and there's litigation, and he's nervous they're going after him as the advisor, the VC people. So my question around that is, this gets into the asset protection and also how are those entities usually set up, and are the backers of this the investors? I mean, this all comes into play, correct, Harry?
Well, it does. It doesn't. That's not really part of the CTA. CTA is a disclosure, and they could be lawsuits or whatever it may be for breach of fiduciary duty by the VC advisor. First of all, the VC advisor, if properly credentialed, is not subject to the act. That's number one. They're an exempt party. And two, if they try to find out ownership interest, it's not public. You can't get to it. So I think the government is very serious about protecting this data, because if they don't protect this data, then the odds of them collecting this data will be nil and none, and that defeats the purpose, the noble purpose of the Corporate Transparency.
Are these VC-backed companies typically set up as LLCs?
Yeah. Well, some of them are set up as LLCs, depending upon, in other areas, some of them are set up as C Corps. And the reason for that is Section 1202 stock, small business stock exclusion, where they can sell their stock, 5 years later and get it pretty much exempted from capital gains tax. There's an exemption for that that only applies to C Corps. What people don't recognize, Paul and Hal, is that they should have set it up as a LLC and then made an election to have the LLC taxed as a C Corp. It still applies. So they could be an LLC to get the protection of an LLC and still get the 1202 small business stock exemption. So you get the best of both worlds if they know how to set that up properly. But I can't switch it. In other words, it's very difficult to switch from an LLC taxed as a partnership to an LLC taxed as a C Corp, because the light came on and now they say, hey, we can get that small business exemption because it has to be original issue stock. All right. And if we originally issued it as a membership interest as an LLC and then switched it to the LLC taxed as a C Corp, there is some question as to whether or not 1202 would still be available to them. It's a highly complicated area of the law, but to answer your question, yes. And all of them need to get registered, not the VC advisor, but the companies, if they don't have the 25 million with CTA.
Yeah.
What a fire hose. Harry. I mean, it's, I got a ton of questions, but I don't know that, you can answer them all right now. Just personally, I've got, I've got a number of LLCs like you, thanks to you, I set up as, two-party owners, one being 99% my trust
Sure.
and 1% me, that kind of stuff.
That's correct. Yep.
And some of them are really, they own property, but they're totally inactive. They're just, I don't even file tax returns because I've got a managing LLC that does all the money,
Right, and the rest are all disregarded. Yes, I know.
So
Every one of them.
every one of them. Wow. And then I just recently set up a family limited partnership for myself and my 4 kids. And right now we all own 20%. And it's really just an investment vehicle. Trying to figure out, I'm working with my adult children to, try to figure out markets and stuff together. And so I guess I got to do all 5 of us.
No, not really, because you're at 20%. So that's below the threshold. So no one qualifies as a beneficial owner of interest. So the company itself, yes. The family limited partnership, yes. But when you have family limited partnership, there's part 2. Gotta have a general partner. The general partner, which may be a 1% owner of the 99%, is the control factor. And the general partner, Hal, set up properly, is not an individual because they have unlimited liability. Usually that's an entity, an LLC of some sort. So the control factor, the GP, if it's an entity, which it should be, needs to file. The entity itself needs to file, but the beneficial owners of interest, the 20%, no one's got 25, so they do not have to file.
Okay. What a cluster.
Yes. Yes.
Yeah. So what about these trusts that are, well, like I said, like finance, all they are investment vehicles just to keep stuff out of probate.
Yeah, well, they're not. I mean, they're just living revocable trusts. So, living revocable trusts to keep things private and out of probate themselves are not filing entities. However, depends on what they own. So, if you just throw your house in there and you threw some bank accounts in there, no problem. There's no filing requirement. If you threw over 25% of a filing entity in there, then the trust becomes a filing entity.
Okay. Well, this has been great, Harry. I
So
know
it's great. It's great to see you again, Hal, and congratulations on all your success. And we look forward to talking to your group about other things in the future as well.
yeah, I'll be sharing this with all the folks. I know there's some particular people I'm going to be pointing to because I know they're
All right, and we're offering, as usual, a complimentary consultation for all your members and anybody else.
I greatly appreciate that.
All right, Hal. Well, thank
Great
you.
information.
Thanks
Thank
so
you,
much.
everybody.
Good to see you. Take care of yourselves.
Thanks, Al.
Bye-bye.
Beautiful. Thanks.